It's now my pleasure to introduce Michelle Mello, Professor of Law at Stanford Law and Professor of Health Policy at Stanford School of Medicine. Thank you very much, Michelle.
Thank you. It's great to be here, and it's great to hear how inspiring the work going on in this space really is. I'm a lawyer by training, and so what I get a lot of at these things is people pulling me aside after the inspiring opening sessions and worrying about what it might mean for them personally, because as we all know, medicine is a space where liability creates an enormous amount of pressure on our willingness to put our necks out and innovate. So I wanted to share a few reflections on some scholarship that I've done in this space of liability for AI tools and how to think about risk management in this space. I'll begin with a few disclosures. I do have some financial relationships in the AI space, most especially my husband, although he doesn't build specific AI tools. So why do people worry about liability for AI? Let me begin by sharing this slide, which was presented at a continuing legal education programs. This is training the lawyers who are going to be advising people like you. And you can see that there's like a cottage industry of lawyers who are making a living scaring people, essentially, about the potential liability consequences of innovation here. They've got this sort of mushroom cloud of like a nuclear reaction triggered by AI innovation, ranging from consequences like malpractice litigation and patient harm to debarment from federal programs. So it's unsurprising that when counsel are getting this kind of advice, and that advice is being passed on to clients, people feel very, very concerned about liability in this space. And the message I want to convey to you is that although there are reasons for concern, I think that as with much malpractice liability, the warnings can overstate the risk here, and particularly overstate the risk at this point in time. With sensible risk management, I think this is a space that can and should continue to blossom at a very rapid pace. So why are people worried? I think reason number one is that compared to other kinds of medical technologies, we just don't have that much pre-market testing going on, at least in a way that creates a lot of public confidence in these products. FDA clearance doesn't happen for a lot of AI products at all, and when it does, it's fairly low-level review. And it certainly doesn't reach into a lot of the human-machine interactions where mistakes could arise with these products. Another reason for concern is that historically, when you have a new technology and there is not a strong system of formal regulation, the courts fill the gaps. The tort law, the personal injury law evolves to create remedies for people who have gotten hurt by these new technologies. And it's typically not until formal regulation steps in that state legislatures begin to kind of reel that liability back in. So I would expect courts to be playing that role for the near future because I do not see substantial federal regulation of AI on the immediate horizon, to say the least. Then there are sort of global reasons to be concerned about liability. One is that with many kinds of AI-related errors, you have the potential for those mistakes to propagate multiple times across multiple patients in an organization, causing a lot of harm. And when you think about who's going to hear cases involving these harms, you're talking about seating a jury of people who, on average, have a high level of distrust regarding AI in healthcare. In a recent poll, 60% of US adults said that they were concerned and distrustful about the prospect of AI being used in their care. So we have potential adjudicators coming in with certain priors about whether harms might indeed be due to something going wrong in the tech, and that's not a great unauspicious start for a trial. Then you have judges who have almost no experience overseeing trials relating to AI or software in general, and as I'll talk about, have very different ideas about how to adjudicate these cases. And finally, because it's such a new area, there's just very little precedent on the books that will guide settlement negotiations or even trials in determining who should bear financial responsibility for harm. In other areas, we have lots of product liability law that sort of gives people a sense of when something goes wrong with the product, the maker of the product should be responsible for this, and there'll be some residual liability for the user of the product if they misuse it, for example. But this is all new. And so for a given tool, it's just very hard to know who's going to be left holding the bag. So I think these are all legitimate reasons why people are worried. But let me offer some additional concerns that pertain to pediatric care, some of which I think you've already talked about today. With regard to the very little testing point, the relative paucity of data for pediatrics means that we can expect, on average, I think lower levels of testing and confidence about products right when they're coming off of the assembly line than would be the case for adult products. A lot of the testing and validation may not be on the exact population that you're planning to deploy a product on, even if it was on a pediatric data set. Given just anatomical changes and the way kids are growing, it's hard to imagine that training would be kind of on all four simulations for each pediatric population that you might be willing to use your tool on. Similarly, when vendors are thinking about training users on how to use their products, they may have primarily clinicians for adult populations in mind. And as we've heard, there are special concerns for pediatric patients and their families. And then with regards to the market, because there's just less incentive to develop tools for smaller populations or healthier populations, there may just be less choice among tools. And so if you're in the position of a hospital department trying to figure out what tools to adopt and deploy, you're not able to pick and choose the safest, best tested tools all the time. You may only have one or two to choose from. And then finally, from a lawyer's perspective, kids make great plaintiffs. When they get hurt, their damages are really high a lot of the time, and they make wonderful witnesses at trial. Their parents make wonderful witnesses at trials. So if we're concerned about the question of how likely is it that a given incident of harm is going to convert to being a medical claim, relatively good prospect in pediatrics for this reason. Now, having said all this, let me offer you a few reasons to be reassured about liability. Even though kids make good plaintiffs, we know now from decades of research, most instances of medical harm don't become malpractice claims. Even the most serious injuries, only 5% of the time, are going to show up as a malpractice claim. So most of the time, when people get hurt in healthcare because of negligence, nothing happens. Secondly, when we've looked at the available legal records for evidence that there's a lot of claiming going on, we don't find it yet. And there's a lot of caveats around that. A lot of claims are just hard to observe in the sources of information that are available to researchers. But there are just very few claims that we can observe yet so far. And then finally, and maybe most importantly, even though kids make good plaintiffs, there are actually a lot of difficulties for plaintiffs to try to prove these kinds of medical liability claims. And let me share some of those with you. So if you are a student in my first year torts class at the law school, I would tell you that in order to prevail in a personal injury claim, it's the plaintiff's burden of proof to prove all these things in the first column up here, that the defendant owed the plaintiff a duty, they breached that duty by deviating from the standard of care, and that breach caused the injury to the plaintiff. Now, why is this hard in the AI liability space? Well, number one is establishing duty usually isn't hard. Physician-patient relationship establishes a duty. But when we think about holding product developers liable, it can be harder because for certain kinds of tech that are deemed medical devices, there is a legal doctrine that says we are not going to allow state law tort claims at all. They are preempted because there's a federal statute that kind of enters this space and that controls what is going to happen. It's not clear exactly what those claims are or which kinds of devices, but there are certainly some kinds of AI where the courts will say you cannot hold the developer liable. To the extent that there's liability here, it's only going to be put on the hospital or the physician. Next, when we get to breach, one of the big problems is with the opacity of AI models. So the plaintiff's job is going to be to prove that there was something defective in the tool that caused an injury, and or the physician did something wrong in relying or departing from the recommendations of this tool. Now that's really hard when you can't tell why the tool made the recommendation that it did, which we all know is a difficulty with most AI models. Similarly, if you're trying to hold a physician liable, the plaintiff's job is to show the physician was unreasonable in either relying on the model recommendation or departing from it. But unless you know something about why the model made that recommendation, it can be hard to prove that the physician behaved unreasonably in following it or choosing not to follow it. Then there are other problems, again, when we think about holding developers liable. In order to hold a developer liable in product liability, you have to have a product. And it may surprise you to know that most of the case law around software holds that software itself is not a product. That's a very immature area of product liability law. It comes from cases involving like investment software. And the courts are now figuring out how to shift that doctrine around to account for injuries related to things like AI-driven cars, and they will. But for the moment, there's some uncertainty about when you can hold a product liability claim viable. And then finally, if you're a plaintiff, you have to show in that product liability claim that the maker of that tool could have used some other design for the software that was safer and also functional. But how do you do that when the product is a mathematical pattern that's encoding statistical patterns from potentially millions of data points? You have to pinpoint a defect in the algorithm. It's not enough to show that something went wrong, yada, 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 somebody got hurt. You actually have to propose a defect in a way that would have been better, that would have avoided this injury, and again, just really hard for AI. Lastly, you have to show causation. You have to show that the injury occurred because of that defect. That may be obvious, but it often isn't. And particularly, it's challenging to think logically about how you hold that a product was defective and caused harm when, on average, it outperforms a physician, for example, in the task that it's doing. Additionally, all models are imperfect. So how do you show that in a given case, the wrong recommendation was a result of a defect when we know that there will be some wrong recommendations some statistical percentage of the time? So plaintiffs will be able to prevail in many cases. They can overcome these barriers, but it's hard. And it's already hard to prevail as a plaintiff. And when we look across malpractice litigation generally, plaintiffs get money about half the time. If the case goes to trial, they lose 80% of the time. And these are in the cases that were selected as being strong enough to go to trial or get settled. So it's going to be very challenging for plaintiffs right now in the adolescence of this area of liability where there's so much uncertainty about how you do this, how you build a case. But this situation is not going to hold. The law always evolves to find a way to help plaintiffs who are disadvantaged by current rules or uncertainties in the doctrine, and I would expect that to happen here. But for right now, I don't see a reason to be overwhelmed by the liability prospects. And indeed, when we looked at 803 cases of personal injury lawsuits involving software, we found only 51 of them related to healthcare products. These are not AI-driven products exclusively, they're healthcare software. They tend to converge around a familiar series of fact patterns, and here's some examples of these. And they suggest some relatively straightforward kinds of interventions to prevent these kinds of claims. So the things to note here are that plaintiffs' lawyers are choosing who to sue: hospitals, developers, and physicians as appropriate to the fact pattern. And that there are many different failure modes represented in these lawsuits. Some of them have to do with the failure of the tool or device itself, but many of them have also to do with a human who made a bad call in relying on that output. So for example, the middle row here was a cardiac sudden death screening algorithm that did not incorporate family history because there wasn't any information about that in the data set. The cardiologist nonetheless decided not to take a family history, and a man who had a parent who had died of cardiac sudden death at a young age died 6 weeks after screening. So some of these, again, are easy cases, but the takeaways here that I took away from this broader review of the law are that it actually is quite difficult for plaintiffs in a number of these cases. We see them getting shut down at a relatively early stage because the plaintiff was not able to prove that there was a defect in the software, or was not able to prove that the physician acted unreasonably in not noticing that the tool had given a wrong output for that patient. There are also real questions raised about what it means to act reasonably in this context, like when should a physician have foreseen that this output was not good to rely on? And the third big takeaway is that judges do not know what they're doing. When you read these opinions, they speak about AI as though it was the same as rules-based software. They seem not to understand the nuances here. And that's unsettling because every time a judge decides one of these cases in a way that gets recorded, they're making law for next time. And so there's some cause for concern that if these claims do get far enough into court that judges are deciding them, the doctrine may go in kind of unproductive directions. So what can we do? I think the message I want to convey is that because risk depends on the tool, the decisions we make about adopting AI tools should also be based on a risk assessment. But the way in which you might be thinking about risk assessment is maybe more simple than I think others, or particularly lawyers, might think about it. So when I speak with developers, they're often very concerned, mostly with the things that are in this box. How likely is it that this tool is going to make a mistake? And part of that is the tool itself just makes a wrong prediction or it generates wrong text. The parts that they're worried about less is what does the human do when they encounter that mistake? So a second really important factor to assess is how likely is it that the clinician is going to make a mistake, either rejecting output in a predictive model or accepting it when they shouldn't. And then a third factor is, what does the workflow look like? How likely is it that because of the way the hospital is choosing to deploy this tool, there's risk that comes just from the way you've put it in there? And I've seen that several times in looking at workflows here. So that, I think, that's job one, figuring out how likely is there to be a mistake. But job two is to sort of reflect on what we learn in other areas of patient safety and ask, what's the likelihood that we can keep this mistake from causing harm to the patient? So what's the opportunity to catch a mistake before it becomes an impact event? And we know, again, from human factors research, other areas of patient safety, that the things we want to look at here are how tightly is the mistake coupled to the patient's body? Is there a buffer of time or human intervention? And if so, what does that buffer really look like? How much time is there for either a human or another automated system to notice and respond to an error? And then what's the situational opportunity to do that? So even if there is time available, based on how human beings work, how likely is it that they're actually going to do it? And that's going to vary depending on things like the visibility of this tool. How easy is it to just forget that it's working in the background? The training that the user has received on what to look for in the tool. And the extent to which automation bias is going to be a problem. Going beyond that, of course, we have to also consider the possibility that this does reach the patient and assess what is the likelihood it's going to cause serious harm. This is where the FDA's own review of AI-driven medical devices focuses on these two things. How sick is the patient, and what exactly is the tool doing with respect to the patient's care? And then finally, when you invite the lawyers into the room, they would layer on a bunch of other considerations that have to do with the likelihood that a harm event will find redress in the personal liability law system. And that has to do with things like how easy is it going to be to prove this case? And how attractive is this plaintiff going to be before a jury? How serious is the injury? Because attorneys work on contingent fee systems. If it's not an expensive error, it's not going to be worth their time. And then finally, how much are we going to be able to figure out how to allocate liability between the people who made the product and the people who used it? So this risk assessment is going to drive in different directions for different tools, and it should. And adoption decisions should really be based on this holistic risk assessment that looks at the benefit of the tool as against this really realistic assessment of causing harm and causing lawsuits. I have a few other risk management recommendations. One set is for adopters. So if you're a hospital system or a department looking at AI tool adoptions, I think in many cases there is a market advantage at this point in time. There are many systems that would like to sell products to a health system like Stanford and may be willing to bargain for important terms in the licensing agreements. So what should those terms look like? What information are you going to give us that's going to help us monitor the safety of this tool? Can you teach us to do this, or can you do it for us? Who is paying in the event of a lawsuit? What kinds of warranties are accepted or disclaimed? And here I'm just going to issue a plea momentarily to founders and to developers. Stop putting sweeping disclaimers of liability in your licensing agreements. I have seen this over and over again. It is stunning, the abdication of responsibility that I've seen on the part of some developers, to the point where they're disclaiming basic warranties saying that their product performs as they represent it to. A fair allocation of responsibility involves some liability for developers, and hospitals should be insisting on that. And then finally, insurance coverage, particularly if it's a small company. Do they have the insurance necessary to make sure that they can be there in the event of a large claim? On the part of users, there needs to be an awareness and an ability to resist automation bias, understanding where it is that humans are likely to become over-reliant on tools, and figuring out how to create workflows that allow them not to do that, and how to train them so that in the 1 minute that they have to assess some LLM-generated output, what should they be looking for? Because what do we know about the failure modes of this tool? That information often has to come from developers, so insisting that that's provided is really important. And then it's just good practice to think about, if this was to cause harm, if this was to go to litigation, what would I want to have documented? So for example, if I've got a predictive algorithm that says this patient's at high risk of something, and I choose not to screen because I know something about the patient that this algorithm doesn't, write it down. Have it in the record. Lastly, think about the role of patient notification in the use of AI tools. I don't think that all patients need to be notified about uses of all tools. But if you think that their decision to accept or reject your treatment recommendation might differ depending on whether or not they know it came in part from the support of an AI tool, it's a good idea to disclose, because that prevents them from layering on to their regular malpractice claim a claim for breach of informed consent. So more information about some of these recommendations are in these 2 articles, which I would love for you to go and take a look at. We're out of time, I think, for this session, but I'm going to make myself available for a few minutes in the lobby. If anyone has questions, I'm happy to take them or to hear from you afterwards. Thank you very much for having me. I hope this has been helpful rather than scary. And I always like to end by reminding people that malpractice suits only happen when somebody gets harmed. And so the best risk management strategy here is always to do the things that we want to do anyway, because we want to prevent harm to patients. Just think about responsible adoption and deployment of AI tools. Thanks very much.